So that is the backdrop against which Justice Brett Kavanaugh, who has been very touchy about criticism of unreasoned shadow docket orders, decided he was going to belly up to the bar and explain how very cool and very legal it is to have apartheid-style show us your papers laws here in America.
Yeah, that's not an exaggeration. Welcome to Law and Chaos, where the Supreme Court shadow docket did the shadiest shit ever. Trump is trying to steal Congress's budget power again, and Alina Habba continues to be very bad at her job. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
Hey Liz, I'm great. How are you?
I mean, it's a lot. The Supreme Court was bad today.
Yeah, but I can't hear you over the sound of this AI slop of George Washington kneeling next to a horse that just came into my
God,
inbox.
you guys, you really have to look at the show notes today. The White House put out the most offensive executive order ever. And,
and that's a high bar to clear, right? This is
I
the
know. I
Olympics
put it
of
in the
crapping
Slack,
it.
and I was like, Andrew, please don't have a heart attack.
No promises, no guarantees. Okay, what are we talking about? July 4th, 2026 will be, by one measurement, this country's semi-quincentennial, right? The 250th anniversary of the Declaration of Independence. I wish I could feel better about celebrating it. But so, look, the White House, perfectly normal, has an initiative called America 250. And part of America 250, I want to read from that website, is to engage and encourage the entire federal government, state and local governments, the private sector, nonprofit and educational institutions, and every citizen across this country to join in this historic celebration. Task Force 250 invites citizens to have a renewed love of American history, experience the beauty of our country, and ignite a spirit of adventure and innovation that will raise our nation to new heights over the next 250 years. And that's fine.
I'm not mad about that part.
No.
Right, fine.
That's absolutely. But as part of today's initiative, they have added the first item on this page, America Praise. And not just praise in kind of a vague sense of like, let's stick it to those atheists like Andrew, but praise in the exclusively right-wing evangelical Christian Southern Baptist, like as sectarians. Okay, I'm going to read a tiny little bit of this until my heart gives out. The ask, what if 1 million Americans dedicated 1 hour a week to praying for our country and our people? The invitation, will you join with at least 10 people to meet each week for 1 hour to pray for America?
I'm sorry, are they like, because I looked at the list and it was like Southern Baptists and Catholics for Catholics or whatever, Opus Dei shit that was. Are they advising you guys to establish a minyan? Is that now your thing? A minyan is 10 people that you have to pray in Judaism.
Oh, I was thinking the little yellow guys from
for God's
Despicable
sake.
Me. Okay, all right. Anyway, yeah, you are not wrong. The initial participating organizations is a list of 35 essentially hate groups from the Southern Poverty Law Center. I mean, a handful are just individual jerks like Alec Brusiewicz and Jack Posobiec and Eric Metaxas, and but almost all of the actual organizations are explicitly evangelical right-wing Christian groups. There are, as you point out, a handful of pre-Vatican II right-wing Catholic groups in there for balance, I guess. I think my personal favorite is that pray.com is one of them, because that is a Christian social networking service.
Spelled with an A, not an E, just in case there were some of you wondering.
Might be. It has a 1.9 star rating on Trustpilot, which I like. The Ebola virus has a 2.5. Like, it's crazy. When you type pray.com into Google, the top results are, I am not kidding, why is pray.com so expensive? And can you get pray.com without commercials? Which, I have to say, extremely on brand for the Trump administration, for the grifters to be on board as well.
Yeah, this is such a gross violation of the Establishment Clause. Like, I don't even know what to say.
There is not much to say, even under the most narrow reading of what the Establishment Clause reads, right? Like the part that the hard right has been foisting on us for 40 years and has now reached its ascendancy with the Roberts Court. They've said, look, separation of church and state isn't in there word for word, so establish a religion just means that the Constitution prohibits us from having a Church of England style church, from preferring one denomination over another, but, and yes, John Roberts has said this in print, quoting Antonin Scalia, there is nothing to stop the country from preferring religion generally over irreligion, which, yes, there is. It's the First Amendment. But leave all that aside, this is explicitly picking a teeny tiny denomination of right-wing Christianity. And, it's not the fifth worst thing that this administration has done today. And,
Yeah, I got to say, I despise the phrase Judeo-Christian because all the people who are saying it are trying to, I feel like use my people as a shield because they're going to try and violate the Establishment Clause or say that these are our values. They're Judeo-Christian values. So I'm real pleased to not be on this list represented anywhere because I don't think we should have any truck with this as Jews. That's my personal opinion. I don't think anybody should have any truck with this, but I am glad to see that there isn't some sort of token group. Maybe I missed it on the list. Token Jewish group having truck with this gross violation.
I'm sure they'll sign up Jews for Jesus any day now. So.
They're not. Do not start with me. Okay, we're moving on.
I'm just poking the bear because you poked me. I know that.
Yeah, fair enough. Okay, with that out of the way, I would like to wish a big mazel tov to Alina Habba, sparkle magic lawyer extraordinaire.
Oh, Lord. What now?
Speaking of. Well, nothing now exactly. Yes, she is still effectively blocking all federal criminal prosecutions in the state of New Jersey because she will not stop squatting in the U.S. Attorney's Office pretending to be in charge. Remember, that's the case where her interim appointment expired and then the administration tried to ninja jujitsu her back into the job by making Habba her own assistant and letting her ascend to the position when it became vacant. I hear she raptured into the position of U.S. Attorney for the state of New Jersey. I don't know. Whatever. It's hella illegal. And now no one knows where any case she touches or her office touches is valid.
Yeah,
but that is actually, it's not. Right. Well, whatever. That's not what we're congratulating her for today.
Not that she doesn't deserve congratulations.
Right. No. Today is about the reminder she just got from the Second Circuit that she is very, very bad at her job, which I could have told them.
And indeed you have for years now.
Thank you. Yeah. Thank you to this horrible idiot woman for years of extremely funny copy. Okay. So this reminder came in the form of an opinion upholding the lower court decision in Carroll v. Trump. That was the first defamation suit filed by E. Jean Carroll, although it was the second to go to trial. That's because the parties spent 2 years wandering around the Second Circuit and the D.C. Court of Appeals while a bunch of judges had a good long think about whether Trump was acting in his official capacity when he said Carroll was a liar who was too unattractive to rape and who was being put up to it by evil Democrats. At the end of all that, the parties agreed that it was the decision of the trial judge, at which point Judge Lewis Kaplan reiterated what he'd said 2 years earlier, which was, no, that is not the president's job. Don't be ridiculous.
Right.
So that case was Carroll won, and it took a long time. But by then, Trump had defamed Carroll some more, and she'd sued him again, adding an assault charge under the newly passed Adult Survivors Act in New York. So in Carroll 2, the jury found Trump liable for sexual assault, but not rape. And they found him liable for defamation and fined him $5 million. And those findings were binding law of the case for Carroll 1 when that case finally went to trial. So Trump could not deny that he'd assaulted Carroll, and he could not deny that the statements he'd made about her were defamatory, not the first time, and not when he repeated them again. And since Trump had continued to lie about Carroll, posting monthly attacks on social media, the second jury awarded her $77 million because they needed a number that would be enough to force him to keep Carroll's name out of his filthy mouth. And clearly the $5 million penalty from the first trial wasn't going to do it.
Right. And all good, and I'm glad we got to reclaim. But there's a song about Alina. Remember Alina?
Yeah, Alina works at the restaurant. No, she pretends to work at the U.S. Attorney's Office in New Jersey. Okay, so Alina represented Trump in both Carroll cases to hilarious effect. Judge Kaplan explaining the rules of evidence to her in words of one syllable was amazing. She did so much crazy shit. But one of the things she did not do, at least not in timely fashion, was assert that Trump was immune from lawsuits based on the doctrine of absolute presidential immunity.
Yeah, that's probably because the Supreme Court hadn't invented it yet, and no one on earth thought that was a real thing before July of 2024. I mean, Alina's a goddamn idiot. I'm not contesting that one, but I'm not sure it's fair to fault her for failing to raise an issue that didn't exist yet.
I mean, that's mighty generous of you. And I guess, to be fair, Todd Blanche and Emil Bovee, who are basically competent, did not mention it either during the New York civil fraud trial. At least, well, they didn't mention it until 5 minutes before the jury was summoned, which just so happened to be when they started pitching that fakakta theory to the Supreme Court. But by then, Judge Mershon said, "No, sorry, too late."
Yeah, and now Todd Blanche runs the Department of Justice, and Emil Bovee is a federal judge with a lifetime tenure on the Third Circuit.
Yeah. Now, this is supposed to be a fun segment, Andrew.
Oh, sorry to ruin the vibe.
Yeah. So Alina tried making the argument post facto that presidential immunity is unwaivable, and thus it was irrelevant that she did not raise it as a defense. She couldn't waive it by not raising it. And Judge Kaplan was like, LOL, that's not a thing, you dingbat. And so Trump appealed the verdict in Carroll 2, which, remember, was the first trial. And the Second Circuit said, right, unwaivable presidential immunity is not a thing, you dingbat. And then Trump appealed the verdict in Carroll 1, and he said, you have to dismiss this because presidential immunity is unwaivable. And the Second Circuit panel said, LOL, still not a thing, you dingbat. But that's hilarious. But it was not the only commentary on Alina's super lawyering skills, because one of the issues Trump appealed was whether Judge Kaplan abused his discretion by not allowing Trump to testify at length about how he couldn't have defamed Carroll because he actually believed all of the things he was saying about her. Slight dog leg. During the first trial, the lead lawyer was a guy named Joe Tacopina, a really good lawyer. And he was smart enough to know that putting Donald Trump on the witness stand would be not good. And it's probably thanks to Tacopina that the jury did not find Trump liable for rape, just for sexual assault. And $5 million in the first trial, not a huge verdict. But Trump is an idiot. So he went on social media and said it was all Joe Tacopina's fault that he lost because he didn't let him get on the witness stand and wow the jurors with his manly charms.
I mean, Joey Tacos doesn't need me defending him here, but I will point out Trump did get on the witness stand in that second case, and the verdict went up like 1,500% actual number.
Mean, yeah, there's that. But see, he was only allowed on the stand in the second trial for like 10 seconds because he wanted to testify that he didn't assault or defame Carroll. And Judge Kaplan said, no, those issues were already decided in the first trial, and you can't tell the jury that because the jury in the first trial said you sexually assaulted her and you defamed her, and you can't get on the witness stand and deny those things, which is what you wanted to do. So he got on the witness stand and he started to deny it, and Judge Kaplan was like, nope, you are done. And that is one of the things which Alina filed the appeal, or I guess it's not her anymore. It's her former business partner, Michael Medallo. But so that was one of the bases for this appeal to the Second Circuit. And this morning, the Second Circuit gave that argument the back of its hand too, first, because again, Alina didn't object in timely fashion, because when Judge Kaplan said, done, you're done, you can't say that, she didn't say, I object. She just sulked or some shit.
That's
whatever.
Just a thing they say on Law and Order to like make the dialogue run snappier.
Right. And the second basis for rejecting this is that the jury got to see plenty of Trump's denials since the plaintiff, that is E. Jean Carroll, played all that deposition footage of Trump saying it never happened and Carroll was a damn dirty liar. Now, the reason that they played those tapes was because that question after that was, what is your basis for believing that, sir? And he said, I have none. Yeah.
That footage was definitely not helpful to him. I'm not sure why anyone could have possibly thought that hearing more from Donald Trump would have been good for Donald Trump's defense. But anyway, here's a little bit of the Second Circuit's holding. They say, the record in this case supports the district court's determination that the degree of reprehensibility of Mr. Trump's conduct was remarkably high, perhaps unprecedented. There was ample evidence that Trump was recklessly indifferent to Carroll's health and safety. Carroll was subjected to ongoing and prolific harassment as a result of these statements, including a multitude of death threats and other threats of physical injury. In some, as observed by the district court, the conduct here supports a significant punitive damages award. It involved malice and deceit, caused severe emotional injury, and continued over at least a 5-year period. So no, the verdict will not be reversed or cut down. Pay up, you filthy bastard.
Yeah. Although the filthy bastard is appealing to the Supreme Court. But yes. And, okay, speaking of Supreme Court, fun times are over.
Yeah, they are. Okay, the Supreme Court's conservatives did 2 truly horrible things this morning, and we will break those down for you in the next segment. But you know what? Before we do that, we're going to take a very brief ad break, unless you are one of our supporters over on our Substack at lawandchaospod.com or on Patreon at patreon.com/lawandchaospod, at which point no ads for you, not now, not ever. And we really appreciate you continuing to support this show, keeping us on the air.
And we're back. Okay, the Supreme Court's conservatives were exceptionally evil this morning, even by their own debased standards. First, they got the ball rolling with a 1-paragraph administrative stay of a ruling in the U.S. District Court for the District of Columbia, declaring that Trump's firing of FTC Commissioner Rebecca Slaughter was illegal.
Yeah, if these were a 1-2 knockout punch, this was the jab. This is another ominous sign that the Supreme Court is just shredding precedent at will, that prior decisions from 5 years ago mean nothing. The only thing that matters is rewriting the rules on the fly to entrench conservative power.
Yeah, it's like dog's leg. Did you see where Justice Barrett was out flogging her book? Like, she's talking to like Barry freaking Weiss and whatever because she's so independent. Justice Barrett said that she does not think about Trump when she rules on a case involving executive power. She imagines that the brief says President Bush or President Biden. It's a way she keeps herself independent in her mind.
Yeah, the judge who countenanced nationwide injunction after nationwide injunction to torpedo the Biden administration over such wide-ranging powers as forgiving student loans, and then in 2025 discovered that nationwide injunctions have been illegal for a century. What's going on? Totally unbiased. She's not thinking of how to benefit Trump at all. How could you even suggest a thing?
Oh, perish the thought.
Yeah, so, okay. Background on this case. We have talked about it a lot. In the beginning, there was Humphrey's executor. Well, not the beginning, but the whole, religious theme. Anyway, in 1935, the Supreme Court upheld Congress's ability to protect executive agency officials from being fired by the president. The court said that President Roosevelt could not fire the commissioner of the Federal Trade Commission without cause in violation of the Federal Trade Commission Act.
You will note that Humphrey and Rebecca Slaughter had the same job.
Foreshadowing. Okay, so for 85 years, we all assumed that the Supreme Court meant what it said and that Congress could set up executive branch agencies and stop the president from just firing those heads on a whim. And Congress did that a lot from 1935 to 2020. It put those kinds of protections that said the director cannot be fired except for cause in dozens of places all the time, assuming, I think correctly, that it contributes to the stability of government to have experts in charge who can render honest service across administrations, team of rivals stuff, and not be fearful of losing their jobs if they offend the current president. But Donald Trump is not about stability or nonpartisan expertise. So in his first term in 2020, he tried to gut the Consumer Financial Protection Bureau by firing its head. And the Supreme Court, long story short, let him. in a decision written by one Chief Justice John Roberts. That was Saylor Law versus Consumer Financial Protection Bureau, a case we have talked about a million times on this show. That's the one where Roberts said, we're not overturning Humphrey's executor. We like our precedent. We're just finding this clause written in invisible ink that says Congress can really only protect members of multi-member boards. Individual agency heads like the CFPB, those are fair game. And how could you not have known that?
Yeah, that was completely concocted bullshit.
Yeah, absolutely. But fine. The Supreme Court can overturn 80-year-old precedent. We knew this court had very little love of anything it didn't write. Then President Biden came into office and spent 4 years living with the world that Chief Justice Roberts created with the Saylor Law decision, right? Like, he fired Trump's guy over at the CFPB because that was what the law said. But President Biden left multi-member boards alone because, again, he thought the Supreme Court meant what it said. That's what the Supreme Court said. And our team, plays by the goddamn rules. Then Donald Trump got back in office and fired everyone no matter what. And the Supreme Court's 6 conservatives let him. In every single case, they have stayed and then overturned lower courts who did their best, who dutifully applied what the Supreme Court said in 2020 in Saylor Law, which, by the way, is what trial court judges are required to do. Because the Supreme Court's 6 conservatives are doing all of this on the shadow docket, and shadow docket orders are not precedential. So, the fact that the Supreme Court stayed an order that would have prevented Trump from firing the members of the National Labor Relations Board does not mean, as a matter of law, that Trump either A, has the right to fire them, right? Like, you can stay a lower court's order and still not make a determination on the merits that the party you're ruling in favor of is correct, right? It's just that they have a likelihood of success. Or B, that Trump can fire members of the Federal Trade Commission because they're kind of like the National Labor Relations Board. Like, none of that follows.
Yeah, although I guess Justices Gorsuch and Thomas seem to think so.
Yeah.
Well, okay, to be fair, they are mostly venting their spleen at lower court judges for not following the Supreme Court's shadow docket vibes in impoundment cases, not so much in these Humphrey's executor type cases. We're actually going to talk about the impoundment cases in a minute. Mm-hmm. But again, the Supreme Court is doing all of this stuff on their shadow docket and getting pissy that trial court judges aren't just ruling and treating all of these precedents as if they're overruled.
Let me unpack that for just a second. What we are calling the shadow docket, that was popularized by Steve Vladeck, friend of the show, is the Supreme Court's emergency docket, their review of requests for stays of lower court orders or emergency injunctions to prevent parties from doing something right away. And the reason that it's called the shadow docket is because the court has to act very quickly, right? Like, the whole reason you need immediate injunctive relief is because the conditions are about to change. And so many of these opinions, in fact, the supermajority of the Roberts Court shadow docket opinions, are not reasoned. They just say things like, on the application for a stay presented to Chief Justice Roberts, it is hereby granted, period, end of. Although, with the increasing frequency of indefensibly terrible shadow docket opinions, we have seen lengthy reasoned dissents from the 3 real justices on the Supreme Court. But the point is, if the Supreme Court doesn't explain its reasoning, which it typically does not, on the shadow docket, then how is a lower court supposed to apply precedent when they don't know what the reasons are, right? And especially when the Supreme Court says, we're not overturning precedent, we're just reaching the opposite conclusion of a case that we decided 5 years ago for reasons that maybe we'll tell you, but not right now.
Right. So the U.S. District Court in D.C. ruled that it was illegal for Trump to fire Rebecca Slaughter, an FTC commissioner, based on Humphrey's executor and Saylor Law, because 1, she had the same job as Humphrey, and Humphrey's executor is still good law until they overturn it. And 2, she is a member of a multi-member board serving for a fixed term, so she should be covered by Saylor Law, which is also still binding precedent. And the D.C. Circuit stayed that ruling, but last week it agreed with the trial judge that Slaughter was entitled to have her job back. And then the administration ran to the Supreme Court and asked for an emergency order, which it got, more or less.
Yeah, that's right. So what the Supreme Court did was enter an administrative stay. And an administrative stay is what you do when you have rapidly changing conditions that come to you on an appeal or at at the Supreme Court a petition for certiorari, and you want to make sure that the reason for that appeal does not dissolve before you get a chance to rule on the merits, right, to decide whether, if you're the Supreme Court, to grant cert or not, right? So if you have somebody about to take off on an airplane, that would be an excellent time, leave the country, that would be an excellent time to grant an administrative stay and say, do not change the conditions on the ground until we can figure out whether we're going to take this case at all, because otherwise you might have somebody go, oopsie, too late, and deprive the Supreme Court of jurisdiction. That's what administrative stays are supposed to be. And prior to January 20th, 2025, that's how we've talked about that on this show and how you've talked about it in print, Liz, right? You don't read anything into an administrative stay because it's just the Supreme Court or an appellate court protecting its jurisdiction so that conditions don't change. And oftentimes you grant administrative stays to parties that would go on to lose when the court actually considered the application, but the court was just protecting its jurisdiction. But that's not. Let's not engage in closing our eyes here and pretending we're back in law school. This is effectively a reversal. This means that Rebecca Slaughter is fired, and she's now been fired on zero legal reasoning.
Yeah. I mean, we've talked a lot about why lower court judges are pissed.
Mm-hmm.
I mean, there was that story by NBC's legal reporter Lawrence Hurley, where he interviewed all of these lower court judges that said, you're throwing us under the bus because they spend months doing real work and the Supreme Court just wads it up and tosses it in the trash without bothering to give them any rubric to rule in the future.
Yeah.
And this is exactly that. And it's shredding precedent for no reason whatsoever.
And shredding the rule of law. Absolutely.
Okay. We're going to take another ad break and we will be right back. And we're back. So after shredding Humphrey's executor, the Supreme Court turned around and said, racial profiling is A-OK. Go for it.
On the shadow docket, obviously. This was the haymaker.
Right. So, okay, this is the case out of California where a trial judge said, no, ICE cannot just descend on communities and grab up every non-white person they see and demand to see proof of citizenship. It's captioned at the Supreme Court, Noam v. Vasquez Perdomo. It's the one where Judge Mami Frimpong of the Central District of California issued a TRO and said, don't racial profile. Here's the operative part of her order. As required by the Fourth Amendment of the United States Constitution, defendants shall be enjoined from conducting detentive stops, that is, detaining people, unless the agent or officer has reasonable suspicion that the person to be stopped is within the United States in violation of U.S. immigration law. In connection with paragraph 1, defendants may not rely solely on the factors below, alone or in combination, to form reasonable suspicion for a detentive stop, except as permitted by law. Factor 1, apparent race or ethnicity. Factor 2, speaking Spanish or speaking English with an accent. Factor 3, presence at a particular location, e.g. bus stop, car wash, tow yard, day labor, pickup site, agricultural site, etc. Or factor 4, the type of work one does. And the Supreme Court said, nope.
Well, to be clear, 5 conservative justices just said nope. They said, again, because it's on the shadow docket, the application for a stay presented to Justice Kagan and by her referred to the court is granted, which has the effect of undoing Judge Frimpong's order pending resolution of the case after it winds its way through the Ninth Circuit and then the Supreme Court in regular process, like that, a year, 2 years, right? And I want to emphasize here that the argument that the government made at the Ninth Circuit against this injunction was, this is an impermissible follow the law injunction. That was their language. They said, you've got to strike this down because it doesn't give us enough guidance. Because all it says is follow the law. And of course we're going to follow the law. So what's it doing here? So that is the backdrop against which Justice Brett Kavanaugh, who has been very touchy about criticism of unreasoned shadow docket orders, decided he was going to belly up to the bar and explain how very cool and very legal it is to have apartheid-style show us your papers laws here in America.
Yeah, that's not an exaggeration. He starts off by saying this is all Joe Biden's fault for letting the country get overrun with undocumented immigrants. He says the government estimates that at least 15 million are in the United States illegally, many millions illegally entered or illegally overstayed just in the last few years. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. About 10% of the people in the Los Angeles region are illegally in the United States, meaning about 2 million immigrants out of a total population of 20 million. Not surprisingly, given those extraordinary numbers, U.S. immigration officers have prioritized immigration enforcement in the Los Angeles area.
Justice Kavanaugh gives absolutely no citation for that back of the envelope math because there is none. As far as we can tell, Pew Research said that in 2022, the last year for which we had data, the entire state of California had 1.8 million immigrants total, of whom less than 20% were undocumented. So no, every 10th person in Los Angeles, 2 million people are not undocumented immigrants. You goddamn racist hack. This entire concurrence is full of just unquestioned right-wing talking points regurgitated back as if we're watching Newsmax and this is a Supreme Court Justice of the United States. Like, skipping ahead in the Kavanaugh opinion, he says that the stay factors for an injunction favor the government, quote, given the millions of individuals illegally in the United States and the myriad significant economic and social problems caused by illegal immigration.
Yeah, citation needed, Brett. That's a moral judgment. It is not a fact. But this opinion does not get better. Kavanaugh goes on to say, the government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants, and who do not speak much, if any, English. If the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. If the individual is illegally in the United States, the officers may arrest the individual and initiate the process for removal.
The upshot, as Justice Kavanaugh knows, is that it is now legal in Los Angeles for ICE to stop and arrest any person who does not have proof of citizenship on them. I mean, how else are they supposed to, following Justice Kavanaugh's imagined colloquy here, learn that the individual stopped is a U.S. citizen? I don't have proof of citizenship on me. I don't take my passport when I walk the dog or go out to the coffee shop or whatever. And in fact, ICE is detaining plenty of citizens. That's actual evidence in the record in this case. But none of that is actually the point. There is no legal obligation in this country for individuals to walk around with identity papers. Or I guess there wasn't until the Supreme Court made that up today.
Yeah, this whole statement is unspeakably vile. Kavanaugh defends using race as a factor in determining reasonable suspicion to detain people, if only in combination with other factors.
Yeah, other factors like speaking a foreign language or speaking English with an accent. And yeah, sure, those are definitely not a proxy for race that they think they can just pass off with a wink and a nudge.
Right. And Kavanaugh suggests that statistical probability can be a basis for reasonable suspicion, which is not law. It has never been the law. That's contrary to every Fourth Amendment precedent. But Kavanaugh kind of waves that away because he wants to pretend that racial profiling is kosher if it's like mixed with math. That's why he has to pretend that 1 in 10 people in LA is an undocumented immigrant, because then he can say it's reasonable to think that all brown people are committing crimes or committing the crime of being undocumented. It's the same as Kristi Noem saying that all these people are gang members or murderers. There's really no difference between her brand of gutter racism and what this Supreme Court justice did. And Kavanaugh concludes by sort of pretending, affecting sympathy for undocumented people who are like fleeing, bad situations in their home countries. But he says that they're definitionally criminals, cheating the good immigrants who wait in line. And thus that these immigrants, these criminals, have no cognizable legal rights, which is also not true. Yeah. Being in the country without legal status is not a crime. It's a civil violation. And it is long established that undocumented immigrants have Fourth and Fifth Amendment rights.
Yeah, I really have no words. I guess I will end by quoting Justice Sotomayor from her dissent. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work at a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent.
Yeah, it is another bitter, bitter dissent by the three liberals. It starts by describing this like supposedly cheerful interactions imagined by Kavanaugh, where the friendly ICE agents say like, "Hello, good sir, might we inquire as to your citizenship status?" Because that's not what's happening. The reality is that these goons are rolling up with their guns out. They're physically grabbing every brown person and detaining them if they can't prove their citizenship, or sometimes even if they can.
Mm-hmm.
Justice Sotomayor points out that speaking Spanish and working for a landscaper or at a car wash does not actually make it more likely than not that the person is undocumented. Like even if Kavanaugh is like, it's not racial profiling, it's just math argument or good law, which again, it's not. But even if it were, the argument would still fail, because if only 1 in 10 people who fits this profile is undocumented and 90% of the people who fit the profile are not undocumented, then you don't have reasonable suspicion that individuals meeting that description are undocumented. You know, it's more likely than not that they're citizens.
Yeah. Let me talk briefly about the law, because with respect to the use of statistics to justify racial profiling, Justice Kavanaugh purports to rely heavily on a 1975 Supreme Court decision called U.S. versus Brignani-Ponce that said race might be allowable as one factor, but that the Border Patrol could not set up checkpoints and grab people just because they were driving while Mexican. They had to have some articulable suspicion as to why a specific car might be harboring undocumented immigrants to justify a stop, which you will recall was the standard that Judge Firmpong put in her TRO. That is, that the suspicion had to be individualized, not blunderbuss racial profiling, because that would cover, and again, this is from that 1975 Supreme Court decision, quote, a large volume of legitimate traffic as well. And then Justice Kavanaugh says, well, that allows ICE to roll up to a car wash and grab every brown person because there are lots of brown undocumented people who work at car washes. But as Justice Sotomayor points out, the court in Brignani-Ponce held the exact opposite. So quoting from Justice Sotomayor, quoting that opinion. Critically, a set of facts cannot constitute reasonable suspicion if it describes a very large category of presumably innocent people. In Brignani-Ponce, for example, the court held that Mexican ancestry alone did not constitute reasonable suspicion to support stops by Border Patrol agents, even near the border, because large numbers of native-born and naturalized citizens have the physical characteristics identified with Mexican ancestry. So too in another case, this one, Brown v. Texas from 1979, the court held that standing in an alley in a neighborhood frequented by drug users did not rise to the level of articulable suspicion because that activity was no different from the activity of other pedestrians in the neighborhood. The Fourth Amendment prohibits exactly what the government is trying to do here, seize individuals based solely on a set of facts that describes a very large category of presumably innocent people.
Yeah. Okay. I mean, we could talk about how what the government did here is terrible. And I think we have. But I'd like to kind of take a step back on a meta level, because if you look at these shadow docket orders, like 5 of the Supreme Court's 6 justices were like, knowing how much flack they've taken for these shadow docket orders, they still were like, let's just say no and keep our mouths shut. And if you look at Justice Kavanaugh's reasoning, you can see why. Because what he's done, right, like he effectively Leroy Jenkins'd in here and was like, let's do racism, right? And of course this is racist, right? Of course. That is why the 5 other conservatives tried to say as little as possible, right? Knowing that they're going to get criticized for doing this on the shadow docket, they still thought hiding their racism, hiding their, hoods under their robes effectively was a better strategy than doing what Kavanaugh did here and copping to it. I mean, look, Kavanaugh, as a secondary thing, said he thought that the plaintiffs in this case lacked standing. And I think that what is likely to happen when this case comes to the Supreme Court is that the other conservative justices will do their very, very best to kick it on standing and not appear to be such gutter racists. Mm-hmm. And what Kavanaugh has done here really undercuts that project.
Yeah, I think that's right. And I think that that helps illustrate why it is important for us to continue to document this and continue to talk about the rule of law. I know that that's a challenge, but this is a direct result, or the fact that we are having this discussion is a direct result of people drawing attention to the fact that the Supreme Court is trying to rewrite the rules without explanation and is demanding that they give them. Because when you demand that they give them, they wind up sometimes accidentally saying the true part out loud. And every time Justice Kavanaugh says something like this, it helps in the project of delegitimizing what the Supreme Court is doing. I know that's not a great ray of hope, but it does illustrate the importance of the rule of law on so many levels.
Okay. We are going to take a break unless you're a subscriber at lawandchaospod.com or on Patreon at patreon.com/lawandchaospod, in which case we're going to revisit one of the craziest members of Trump 1 and 2, both administrations. That would be Peter Navarro. For everyone else, we will see you after this brief ad break with a story about a Trump advisor who is not dumb, but is plenty evil. All right. We'll see you in a sec. And we are back. Okay. On the Friday before Labor Day, the Trump administration put out an announcement titled Historic Pocket Rescission Package Eliminates Woke, Weaponized, and Wasteful Spending.
Counting the title, this announcement used the word woke 4 times in 2 paragraphs, which I think is Trump world speak for, please don't notice that the Wall Street Journal did in fact publish that Epstein poem I totally didn't write.
God, that picture is terrible. We're not going to talk about it today,
the fake one was less offensive. Okay, yeah. Please, go ahead.
So this announcement says that the Trump administration is committed to getting America's fiscal house in order by cutting government spending that is woke, weaponized, and wasteful. Now, for the first time in 50 years, the president is using his authority under the Impoundment Control Act to deploy pocket rescission, canceling $5 billion in foreign aid and international organization funding that violates the president's America First priorities.
Yeah. From a legal perspective, it's funny to see that language for the first time in 50 years because the Impoundment Control Act was passed in 1974, which is 51 years ago. So what that boast actually means is no president has ever asserted that they have the authority to deploy a pocket rescission before because pocket rescissions do not exist. The president cannot just cancel foreign aid that Congress passes into law. A pocket rescission is something invented out of the mind of Donald Trump's director of the Office of Management and Budget and the architect of Project 2025, Russ Vought, one of the worst villains of the Trump administration. And yes, that's a long list. See, Vought was the guy who helped Trump break the law this exact same way back in 2019. So he's had a while to stew about it and come up with what he thinks is one weird trick that he now thinks lets Donald Trump do a thing that was so illegal 6 years ago that it got his boss impeached, but now is fine. It's crazy.
Okay, so last week, Judge Amir Ali of the U.S. District Court for the District of Columbia enjoined this pocket rescission. That is Trump saying, I have decided unilaterally I'm not going to spend money allocated by Congress. And he ordered the State Department to disperse the funds. So today, Trump raced to the Supreme Court. He skipped over the D.C. Circuit, and he asked for a stay of Judge Ali's order. He finally got a emergency appeals panel in the D.C. Circuit that isn't 2 Trump appointees and 1 normie. So now he knows he's going to lose. That's why he's skipping the D.C. Circuit. As background, we had a great interview with Bobby Kogan, who was formerly of the Office of Management and Budget under President Biden in episode 102, where he explained all of this stuff about the pocket rescissions and exactly what impoundment is. So if you want to go back, that was a terrific interview, episode 102. But starting at the top, the Impoundment Control Act is not a source of presidential authority, which Trump kind of pretends in his announcement. It is actually a constraint on presidential exercise of power. And it's been a thorn in the side of this president, in particular since his first term, when, as you said, he got impeached over it. Article 1, Section 8, Clause 1 of the Constitution is the spending clause, and it says, Congress shall have the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. Which means in plain English that under the Constitution, Congress has the power to collect taxes and set the budget, not the president. And Also tariffs, by the way. Congress has power over tariffs. But that's not what we're talking about right now.
Right. Look, the executive branch does have a lot of power over how funds that have been allocated by Congress can get distributed to individual recipients. They get to make choices. But the one thing we know presidents definitely cannot do, because it's the thing that the Impoundment Control Act was passed to prevent, was for a president to just say, nah, not going to spend the money at all. So,
yeah, can I just break in for a sec to clarify something? Because the Impoundment Control Act isn't what stops the president from doing it. It's the Constitution that stops the president. The Impoundment Control Act was a law that Congress passed to say, no, for serious, cut that shit out.
Yeah. Well, let's actually talk about the history of the Impoundment Control Act a little bit, because you're exactly right. And when you discuss how it came into being, it becomes just so clear. So, Liz, let's time travel back to 1972, before either of us were born.
Really?
Yeah. Commander Cody and his Lost Planet Airmen had just released Hot Rod Lincoln, and Congress,
I'm pretty sure you were there.
It was not, had passed the Federal Water Pollution Control Act over President Richard Nixon's veto. And that act directed that the executive spend $5 billion in 1973, $6 billion in 1974, and $7 billion in 1975 to fight water pollution. But President Nixon ordered his head of the Environmental Protection Agency, a guy named William Ruckelshaus, not to allot the amounts that Congress passed into law, but instead to allot no more than $2 billion in 1973 and $3 billion in 1974, which is less than half of what Congress said.
Right. And that case went to the Supreme Court, which eventually ruled that Nixon's EPA did, in fact, have to spend all of the funds allocated by Congress. That case was Train v. New York. But while Train was being litigated, Congress passed this Impoundment Control Act so that Nixon wouldn't try to impound any other funds they told him to spend. We will link to it in the show notes, but the Impoundment Control Act is 645 pages long, and one of the pages is codified at 2 U.S.C. Section 683, which governs rescissions. And it unambiguously says that if the president wants to spend less money than Congress approved, he has to ask Congress to pass a law. And there's absolutely no executive branch authority to cancel funds because spending is Congress's job. And again, this law is what stops the president from seizing control of the budget. That is the Constitution. This is a mechanism where Congress said, look, if you have thoughts about it, you can come to us. But really, we mean it. Don't steal our authority.
Right. And to implement that, Section 283 has two subsections. Subsection A says that the president must transmit what's called a special message to Congress. And that special message has to lay out 5 things: the amount that he would like Congress to claw back, the reasons why, the budgetary, economic, and programmatic effects of that proposed rescission, and all of the supporting facts and data that explain why. And then subsection B says that Congress has up to, but not more than 45 days to consider the president's request. And unless they pass a law in that time rescinding some portion, as the president asked, the president must spend the money, and, this is the language, that the funds made available for obligation under this procedure may not be proposed for rescission again. So during those 45 days, the funds stay in a kind of escrow, but the law says that they shall be made available for obligation unless Congress changes the law. Not up to the president.
Right. So TLDR, if the president wants to not spend money allocated by Congress, he has to ask Congress for approval. And he can only ask once, right? If he doesn't get it, he has to disperse the funds. He can't just ask every 45 days, can I not? Can I not?
Right.
But this is where Russ Vought had his brainstorm, because back in 2019, Congress allocated funds for Ukraine, defense funds to help it fend off Russia. But Trump did not send the money to Ukraine. We all remember that. Instead, he summoned President Volodymyr Zelensky and said, we'll give you the money, but you have to do us a favor, though. And that favor was to announce an investigation of Joe and Hunter Biden. But while Trump was leaning on Zelensky, Russ Vought, in his position as director of the Office of Management and Budget, sat on $214 million of Ukrainian aid and didn't tell Congress about it for a long time, which was illegal. And to be clear, that's what Trump wants to do now. He wants to unilaterally cancel foreign aid just because he doesn't like it. But now Vought has come up with, I think, one weird trick to like cancel that aid forever and make sure that it never gets spent. And we'll talk about that after this brief ad break.
Yeah, and before we get to Vought's one weird trick, I just want to nail down that Vought absolutely 100% knows that this is not the law because, as you pointed out, Liz, he was roundly criticized by the Government Accountability Office for having stonewalled Congress in 2019. And then, on his second to last day in office, on January 19th, 2021, he sent a pissy letter to the House Budget Committee, still defending Trump's right to break the law. But here's what he said, and this is why it's an admission. Vought in 2021 said, the president may need to temporarily pause expenditures to allow the process for making such determinations to play out. As explained in greater depth below in this letter, these temporary pauses constitute programmatic delays, not impoundments. So, Vought argued that what he did in Ukraine, what he and Trump did in Ukraine, wasn't a rescission, it was a programmatic pause, to which the Government Accounting Office basically said GTFO. And because Trump was leaving office the next day and, was never coming back, that should have been the end of it.
Right. Well, to be clear, what the GAO actually said was faithful execution of the law does not permit the president to substitute his own policy priorities for those that Congress has enacted into law. OMB withheld funds for a policy reason, which is not permitted under the Impoundment Control Act. The withholding was not a programmatic delay. Therefore, we conclude that OMB violated the Impoundment Control Act. So, okay, that's 4 years ago. Russ Vought has spent a lot of time thinking about this and writing about it for Project 2025. In fact, he wrote in the Project 2025 manifesto that he thinks the Impoundment Control Act is unconstitutional and there needed to be a guy in charge of the OMB and a chief counsel for OMB who would have the balls to challenge it. And wouldn't you know, he's the guy in charge of OMB. And Clarence Thomas's best friend, that lawyer Mark Paoletta, he's the lawyer. Chief counsel for OMB. So, okay, now Russ Vought is back in office, and the new fiscal year begins October 1 of 2025. All funds allocated by Congress must be spent by then. So here's the trick. If Trump sends that special message to Congress within 45 days of October 1, this escrow period created by that Section 683B of the Impoundment Control Act will allow them to safe harbor themselves over the finish line, run out the clock, and never spend the money, which that's like what he's calling a pocket rescission.
Yeah, analogous to the pocket veto. And if you're thinking that that's insane, congratulations, you're the Government Accountability Office. Because on December 10th, 2018, they issued an opinion letter addressing this precise question. It is B-330-330. It says, an impoundment is any action or inaction by an officer or employee of the federal government that precludes obligation or expenditure of budget authority. The president has no unilateral authority to impound funds. The Impoundment Control Act of 1974 allows the president to impound funds when he transmits a special message in accordance with the ICA. At issue here, so this is the question, is whether the ICA allows such an impoundment for fixed period appropriations expiring during this 45-day period to continue through the date on which the funds would expire. We conclude that the ICA does not permit the impoundment of funds through their date of expiration.
Right. Now, opinion letters are not law, but orders from a federal judge are. Okay. So in 2024, Congress appropriated $30 billion to the State Department and USAID for foreign aid. And Trump wanted to cancel a lot of it. As you know, he wanted to feed USAID to the wood chipper. There's been extensive litigation over this, particularly in two cases denominated AIDS Vaccine Advocacy Coalition v. Department of State and Global Health Council v. Trump. We've been talking about those cases since February. And they're in front of Judge Amirali in D.C.
Yeah, and Judge Ali entered a temporary restraining order. That got overturned at the Supreme Court. That got sent back. And the parties have been litigating since February. And here's the truly bad faith part. Because we talk about the Trump litigation strategy a lot, right? In all of these cases, they immediately run to the appellate court and or the Supreme Court and demand a stay of the lower court orders. But here, the government's been slow walking its litigation appeals, right? They did not request a stay from the D.C. Circuit. Instead, what they said was, well, we'll just let things run its course. As long as the D.C. Circuit rules on our appeal by August 15th, 2025, which, if you're counting, is 45 days before the calendar year expires, then we will, and they said this in open court, it would be feasible to obligate funds pursuant to an adverse decision expiring on September 30th, 2025. And you see where this is going.
Right. As of now, there's $11.5 billion in funds for foreign aid that were authorized by Congress and have not been spent. And the president is required to spend them, but he's already said he's not going to do it. And because the D.C. Circuit did not issue its mandate until August 28th, Trump sent his two U.S. 683B special messages to Congress that night. And so far, Congress hasn't done anything. They're not going to give him permission to withhold the money. But Trump and Vought think they've market timed this so that they've now been able to trigger this super secret pocket rescission because there are fewer than 45 days left on the clock and they can just run it out.
Yeah. Judge Ali was not impressed with this end run around the law. He noted that the argument, quote, finds no support in the text of the Impoundment Control Act, and further that it would undermine the very purpose of the Impoundment Control Act by turning its protections against impounding funds into a mechanism for doing so, which is a pithier way of what took us about 10 minutes to say. Right? And then he documents at length the way the government slow-walked this case. He says, take the circumstance here. It is undisputed the relevant appropriations acts have been valid law from the time they were enacted in 2024 to today. For almost all of that period, defendants did not even dispute that the laws were mandatory and required them to spend the funds. The president never asked Congress to rescind the funds at issue, even though he successfully sought rescission of analogous funds in May of 2025. This was so despite plaintiff's lawsuit and despite the fact that neither the temporary restraining order nor the preliminary injunction impeded the president's ability to propose a rescission and give Congress the full period to answer or not. Defendants, instead, several months after the preliminary injunction was issued, raised the possibility of proposing a rescission within the 45-day window, apparently on the theory that this would cause the funds to expire. So Judge Ali says, no, pocket rescissions are not a thing, but today, Monday, as we record this, Donald Trump once again ran directly to the U.S. Supreme Court, bypassing the D.C. Circuit Court of Appeal, even though he's not allowed to do that, with a request for a stay. And the Supreme Court has not yet acted, but we will continue to monitor.
Yeah, that's some bullshit right there.
It sure is.
Okay, that is going to do it for us today. Thank you guys so much for supporting the show. You know how to subscribe, patreon.com/lawandchaospod or lawandchaospod.com on Substack. And if you can't support the show, we would love it if you would give us a 5-star review on your podcast platform of choice. Okay, we will be back Thursday with written content, and we will be back Friday with another show. Thanks, guys.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.